Without a trust, Florida courts control everything you worked for. Most Florida residents think a will is enough to protect their family. It is not. Florida's probate process is expensive, public, and slow, and a will does not avoid it. A trust does. Whether you own property, have children, or simply want control, this video will show you exactly why a trust changes everything. Why Florida is different from every other state. Florida has one of the most complex and costly probate systems in the entire United States. Probate is the court-supervised legal process that distributes your assets after you die. In Florida, probate is governed by the Florida Probate Code under Chapters 731 through 735 of the Florida statutes. If you die with assets in your name alone and no trust in place, those assets must pass through probate court before your family sees a single dollar. Florida probate can take anywhere from 6 months to 2 or more years depending on the complexity of the estate. Attorney fees in Florida probate are set by statute under Section 733.6171 and are based on the gross value of the estate, not the net value. That means if you own a home worth $400,000 with a $350,000 mortgage, the attorney fee is calculated on the full $400,000. These fees are not small. On a $400,000 estate, statutory attorney fees alone can reach $15,000 or more. A trust eliminates this entirely. What exactly is a revocable living trust? A revocable living trust is a legal document that you create during your lifetime. You transfer ownership of your assets, your home, bank accounts, investment accounts, and other property into the trust. You name yourself as the trustee, meaning you remain in complete control of everything while you are alive. You can change the trust, add assets, remove assets, or revoke it entirely at any time. Nothing changes in your day-to-day life. When you die, a successor trustee, someone you have already chosen and named, steps in immediately and distributes your assets according to your exact instructions. No court, no judge, no probate, no waiting, no public record. Under Florida Statute 736.0101, known as the Florida Trust Code, a properly drafted and funded revocable living trust is one of the most powerful estate planning tools available to Florida residents. Reason 1. Avoiding Florida probate entirely. This is the single biggest reason Florida residents need a trust. As explained above, probate in Florida is expensive and time-consuming. It is also completely public. Anyone can walk into the courthouse and read every detail of your estate, what you owned, what you owed, and who received what. Your family's financial situation becomes a public record for the world to see. A revocable living trust passes assets directly to your beneficiaries outside of probate. There are no court filings, no statutory fees, and no public disclosure. Your family receives what you intended on your timeline with complete privacy. For most Florida families, avoiding probate alone justifies the cost of creating a trust. Reason 2. Florida Homestead and real property. Florida has unique homestead laws under Article X, Section 4 of the Florida Constitution that protect your primary residence from creditors. However, these same homestead laws create complications when it comes to transferring real property at death. Florida law restricts how homestead property can be devised if you have a surviving spouse or minor children. A properly drafted trust that is coordinated with Florida's homestead laws allows you to transfer your home smoothly to your intended beneficiaries while still preserving homestead protections during your lifetime. If you own real estate in Florida, whether it is your primary home, a vacation property, or investment real estate, a trust is the cleanest and most legally sound way to ensure that property transfers exactly as you intend without court involvement. Reason 3. Planning for incapacity. A trust is not only a death planning tool. It is also an incapacity planning tool, and this is something most people never think about until it is too late. If you become mentally incapacitated due to illness, injury, dementia, or any other condition, someone needs to manage your finances and pay your bills. Without a trust, your family may have to petition the Florida courts to appoint a guardian over your finances through a guardianship proceeding under Florida Statute Chapter 744. Guardianship is expensive, invasive, and puts a judge in control of your financial decisions. With a revocable living trust, Your successor trustee steps in immediately and manages everything on your behalf without any court involvement whatsoever. Combined with a durable power of attorney, a trust gives your family the tools to handle a crisis without lawyers and judges getting involved. Reason 4. Protecting minor children and beneficiaries. If you have minor children, a trust is essential. Florida law does not allow minors to directly inherit significant assets. If you die without a trust and leave assets to a minor child, the court will appoint a guardian of the property to manage those funds until the child turns 18. At 18, the child receives everything in a lump sum with no restrictions. A trust allows you to control exactly when and how your children receive their inheritance. You can specify that funds are distributed at age 25 or 30, that money can only be used for education or health expenses, or that distributions are made in stages over time. You decide, not a judge, and not an 18-year-old who may not be ready for a large inheritance. A trust also protects beneficiaries with special needs. A properly drafted special needs trust under Florida law ensures that a disabled beneficiary continues to qualify for government benefits like Medicaid and supplemental security income while still receiving supplemental support from the trust. Reason 5. Out-of-state property owners. Florida is one of the most popular states for owning second homes and investment properties. If you own real estate in multiple states and you die without a trust, your estate must go through probate in every single state where you own property. That means multiple probate proceedings, multiple attorneys, multiple sets of fees, and significantly more time before your family receives anything. A revocable living trust that holds title to all of your real estate, regardless of which state the property is located in, eliminates the need for multiple probate proceedings entirely. This alone makes a trust invaluable for anyone who owns property in Florida and another state. When should you set up a trust in Florida? The honest answer is that the best time to set up a trust was yesterday. The second best time is today. Here are specific life events that make creating a trust urgent. You purchase real estate in Florida. You get married or remarried, especially in a blended family situation. You have children, particularly minor children or children with special needs. Your net worth exceeds $100,000 in any combination of assets. You are diagnosed with a serious illness. You own a business. You have beneficiaries who struggle with financial responsibility, addiction, or debt. Any one of these situations makes a trust not just helpful but necessary. What does a trust actually cost in Florida? A basic revocable living trust drafted by a Florida estate planning attorney typically costs between $1,500 and $3,500 depending on complexity. A comprehensive estate plan that includes a trust, pour-over will, durable power of attorney, and healthcare directive generally ranges from $2,500 to $5,000. Compare that to the cost of Florida probate, which can easily reach $15,000 to $30,000 or more on a modest estate, and the decision is clear. A trust is not an expense. It is an investment that protects everything you have built. The trust must be funded. This is critical. One of the most common and costly mistakes Florida residents make is creating a trust and then never transferring their assets into it. An unfunded trust is a useless trust. Your home must be deeded into the trust. Your bank accounts must be retitled. Your investment accounts must be updated. If assets remain in your personal name at death, they still go through probate regardless of whether a trust exists. Funding the trust is not optional, it is the entire point. Conclusion. A trust is the foundation of every sound Florida estate plan. It protects your family from probate, gives you control over how your assets are distributed, plans for incapacity, and keeps your financial affairs completely private. Whether your estate is modest or substantial, a trust works for you. Do not leave your family's future to Florida's probate courts. Visit undzlaw.com right now to speak with a Florida estate planning attorney who will build a trust that protects everything you have worked for. Serving clients throughout Florida and Nevada. The link is in the description below. One conversation today protects your family forever. Subscribe for more real Florida legal guidance. Because protecting your family starts with knowing the law.